Speaker.
Order.
Item 2, Protection from Online Falsehoods and Manipulation Bill, second reading.
Leader.
Mr. Speaker, may I seek your consent and the general assent of members present to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order number 48.8 to remove the time limit in respect of Minister Shanmugam's speeches.
I give my consent. Does the Leader of the House have the general assent of honourable members present to so move? Aye. Leader, please proceed.
Mr. Speaker, I beg to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order number 48.8 in respect of Minister Shanmugam's speeches.
The question is, as moved by the Leader of the House, as many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Minister for Law.
You've got good eyesight. Thank you, sir. As I start, with your permission, Mr. Speaker, may I ask the clerks to distribute the handouts?
Please do.
While they are being distributed, I'll start. So this bill comes after a long process of public consultation, beginning on the 5th of January last year. Green paper by my Ministry of Law, as well as Ministry of Communications and Information, highlighted the serious nature of the issues, the significant impact in other countries, and on the 5th of January we asked Parliament, and Parliament did so appoint a select committee to examine 4 broad issues. The select committee, which I will call SC, then held public hearings, received 169 written representations from a broad cross-section of society. The SC then prepared a detailed 279-page report. Many of the issues which have been raised since the bill was first tabled in Parliament repeat the points that were canvassed quite extensively during the SC hearings. Points like falsehoods, how to define them, how to differentiate from opinions, the possible different decision-making models like executive powers, independent body, courts, and other such points. Some of the discussions since the bill has been tabled, I think have not considered what the SC has said or the evidence that has been presented and the balancing between the different interests that the SC had to do. I hope the discussions in this House will be better informed by reference to the Select Committee's report. So in this speech, I will first explain the existing powers in law for dealing with objectionable material and contrast that with the powers under the bill. Second, why the bill is being brought before this House now. And third, the need and rationale for the bill. Fourth, new media and the weaponization of falsehoods. And fifth, deal with some of the concerns that have been expressed. And finally, conclude. My colleagues, Ministers Ishwaran, Edwin Tong, will deal with the key provisions of the bill and how they implement the Select Committee's recommendations. Minister Ong Ye Kung will speak on the universities, and my colleagues Zaki and San Shui Ling will also speak in addition to other MPs. First, the powers that the government has under existing legislation. They are wider than what is proposed under this bill. As we consider the bill, the first question is, what are the government's powers under existing legislation? And what can the government do about objectionable material now? In essential respects, existing powers are wider than those proposed under the bill. Let me return to the current legislation. can refer to the Broadcasting Act, the Telecoms Act, various other pieces of legislation. Collectively, they give the following powers. They allow orders to be made for takedown of any material that's objectionable on grounds of public interest. The statements do not have to be factual or false. They can be true, they can be opinions, they can nevertheless be taken down, ordered to be taken down under the current law. 2, current laws also criminalize the transmission of false or fabricated messages, including on the internet. Licensed newspapers, broadcasters, including on the internet, can be required to carry clarifications, other content. The ministers can order to restrict financing, technical support to offending websites, and restrict their reach. Can block offending websites and access to objectionable material. Section 16 of the Broadcasting Act allows IMDA to direct a broadcasting licensee to take such action with regard to content as it considers necessary to comply with the Act. Some of these powers have existed since the 1960s. Others were added on subsequently with development of technology. Laws have been updated. Many of these powers also apply to online material. The Internet revolution took off in the 1990s. 1996, the class licensing scheme under the Broadcasting Act for Internet content providers was put in. The Internet content providers, ICPs, are automatically licensed. All have to comply with guidelines under the class license conditions and the Internet Code of Practice. IMDA has power to take down content that goes against, and I quote, public interest, public order, national harmony, amongst other grounds. 2013, then MDA put in place a new individual licensing scheme for news websites which report regularly on Singapore. Also required online news sites to remove within 24 hours content which was in breach of standards and posted a performance bond of $50,000. The new regime harmonized the legal framework for online news sites with the framework for traditional news providers. At that point in 2013, members will recall some persons created the Hands Off My Internet movement, Free My Internet rally in Hong Lim. Some painted doomsday scenarios, there are going to be chilling effect on free speech, death of free speech, and so on. And online statements were circulated to take a strong stand against the licensing regime, online petition as well. All of that had little to do with the truth. Prior to the 2013 regulations, online news sites already had to comply with the same content standards. So there was no change in content standards. Post-2013, discussions online carried on as before. So from 1996 to 2019, or the 23 years that you have had the class licensing scheme, takedowns were used mostly for sites and services with pornographic content, solicitation of sex, sex chats, religiously offensive content, extremist content. Most people in the street don't even know of the BA or other legislation and no impact on what they have been saying. The powers under the BA have been used judiciously and discussions have carried on as before. The arguments made in 2013 against the changes are similar to the arguments that are being made now, and I will explain that later. They also have no connection to reality. I will now make the point that the bill provides for a narrower set of powers compared with powers that the government already has. This is an important point when we make philosophical arguments in this House. Earlier, I sketched out existing powers, and I've said the bill is narrower in essential respects because it only applies to false statements of fact, and in addition, it must be shown that the falsehoods are against public interest, which is set out in some detail in the bill. The four aspects of the bill that have been commented upon by those who are opposed: takedown of material, takedown can be ordered by ministers, definition of public interest, definition of falsehoods. I'll deal quickly with all four. Current position, if you compare the first point, the BA is broader on the types of material that can be taken down. The bill is narrower. IMDA can direct licensees to remove content. It has the power to impose further obligations on licensees through the licensing conditions to correct falsehoods or shut down fake accounts. IMDA can also require a licensee to carry any correction as directed. Second point, powers under the BA exercised by a minister today, and there is no direct appeal to the court. It's only by judicial review. The third point, public interest. Definition under the current law is wider, and the grounds for taking action are also broader. Any statement, whether true or false, factual or opinion, if it's objectionable against public interest, national harmony, can be ordered to be taken down, subject to judicial review. Bill is much narrower. Fourth point, falsehoods. How do you define? Dealing with falsehoods is not new. Section 45 of the Telecoms Act criminalizes falsehoods transmitted over the internet and other modes. And courts have long had to deal with the question of falsehoods in the law of torts, contracts, criminal law. Section 45 of the TA was repealed yesterday, subsumed under the MOA and the Penal Code, and the relevant provision on transmitting falsehoods is now under Section 14D of the MOA without any change. It's just been transported over. So some of the discussions by those opposed to this bill fails to consider what the SC report has said and seems to be without an understanding of the existing position. Let me now deal with the second point. It's not just narrower in scope, but it also gives greater judicial oversight compared to the current law. Existing powers on takedown of objectionable material, the government responses to be carried, other orders to be made. What oversight does the court have today? It's by judicial review. POFMA, the bill, on the determination of falsehoods, the court oversight is by way of direct appeal. And that was a considered decision by the government. And the process will be made fast and inexpensive for individuals. Other exercise of government powers under the bill, judicial review will be available, as is the law now. So whatever concerns there are about the bill, they cannot logically have been increased by this bill. And lawyers will know when you have a narrower bill and the facts come within the narrower bill as opposed to the broader law, in general, the narrower act will apply. So in fact, that represents a narrowing of the current position. So as members speak, I hope the debate will be based on an understanding of the current position. And I'll do that by putting a series of questions. Does the current law already criminalize transmission of falsehoods? Answer is yes. Does the bill take a narrower position? Answer is yes. So these arguments about definition of fact, these concerns cannot be new. We have had similar provisions all this while with less judicial oversight. So how does the bill increase the concerns? Second, takedowns, corrections. Are they possible now? Answer is yes. Third, can a minister order takedown now? Answer is yes. Fourth, can a minister order takedowns on broader grounds than under the bill? Answer is yes. Fifth, does the bill give greater judicial oversight? Answer is yes. So having said that, members can then ask, if the powers are narrower in essential respects, why is the government introducing this legislation? Why not just rely on existing legislation? The existing legislation with broad powers has been in place for some time, or have been in place for some time. After the SC process, we decided, let's have new legislation with a narrower set of powers than under existing legislation, focused on online falsehoods, with remedies that are more calibrated and provide for greater judicial oversight over executive action. It's designed specifically for the Internet rather than rely on existing legislation, and to deal specifically with online falsehoods rather than the broader areas that are covered under the BA. An alternate approach was entirely possible, which would be to rely on existing legislation with slight tweaks and add subsidiary legislation. If we relied on existing legislation, what we want to achieve under this bill can be achieved as follows. First, rely on the BA, Broadcasting Act, as it is now, for correction directions, takedown directions, general correction directions, and demonetization to some extent. Section 16 of the BA allows IMDA to direct a licensee to take such action with regard to content as it considers necessary to comply with the Act. So that would be the BA. And then you have subsidy legislation under the BA, which can be passed with account restriction directions, declaration of online location, advertising levers. Then you move on to the existing class licensing scheme, can also be amended through subsidy legislation to cover provision of content by individual publishers and clarify that Internet intermediaries like Facebook and Google are also covered. So all of this could have been done under subsidy legislation. The only thing that would have required a statutory amendment would have been one point under the Broadcasting Act to the territoriality provision to include Internet intermediaries based outside of Singapore. But that really is not in dispute. I don't think anybody in this House will say we shouldn't cover Internet intermediaries based outside Singapore. If we had taken this alternate approach, the powers would be broad and there would be less judicial oversight. Issues that have been raised, fact versus falsehoods, public interest, ministerial action, all, there would be no amendments needed for the legislation. Can rely on existing legislation. Members can therefore see, if we had relied on existing legislation with appropriate amendments, and if you map that against issues that have been raised in public, fact versus falsehoods, public interest, ministerial action to take down, there would have been no need to amend. If we had taken that approach, the result would have been an instrument with none of the calibration that the bill proposes or the extent of judicial oversight, which is also going to be made